Lincoln would deal with many constitutional issues during the Civil War. He would deal with emancipation. He would deal with the arrest of civilians. He would deal with printing money. And I think his training as a lawyer taught him to read laws and the constitutional text very carefully. He would look at the Constitution and he would say, okay, what does this allow? What does it not allow? Where does it speak plainly? Where is it silent? Where might it allow me to do something and where does it not? And I think his thinking and training as a lawyer then taught him how to make those sort of decisions.
Lincoln's experience on the circuit influenced him because he was a lawyer as a president. He did not have a lot of administrative experience, but his legal experience filled that gap very nicely.
The Republican Party was this fusion party, so he wanted to have his cabinet reflect that. That's why you had former Democrats, you had former Whigs, you had former know-nothings who eventually became part of his cabinet. Most of these people were lawyers. So Lincoln is looking at his cabinet as a law firm, which he, as the head, is managing. And so I think surrounding himself in his cabinet with people who had differences of opinions with him allowed him to kind of take in all of these differing viewpoints and then make what he thought was the best judgment.
Lincoln believed that secession was illegal and unconstitutional. At the same time, Lincoln did believe that there was a right of revolution. You can overthrow the government if your plainly written rights are being violated. But then Lincoln made the case that that's not what was happening in 1861.
So when he comes into the White House, the position that Lincoln has taken is that he hates slavery. There's no doubt about that. But he's a lawyer, and as a lawyer president, he has to respect the fact that, to some degree, the U.S. Constitution protects slavery in the states where it already existed. So he argues it from a legal point of view. Those Emancipation Proclamation orders only extend through those states that have illegally seceded from the Union.
This was a very technical legal document that he was writing, and he knew that this was a war measure. That's why he also campaigned hard for the passage of the 13th Amendment, which declared slavery illegal everywhere.
A writ of habeas corpus tells the person detaining the prisoner to bring the body of that person into court and to explain what is the justification for imprisoning this person. But Lincoln looked at the situation in April of 1861. Congress was out of session, so they weren't there to do anything about it, and he had a rebellion on his hands.
What Lincoln was doing as president is that he was rounding up people and putting them in prison without saying why he is putting them in prison. And by suspending the writ of habeas corpus, now these people didn't have a way to get out of these prisons that they were being put into.
And from Lincoln's perspective, the Constitution actually doesn't say who has this power. It just says it shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. David Davis was really wary of Lincoln's use of martial law, and in particular, Lincoln's use of military courts to try civilians. And there are a lot of people who would argue that Lincoln abused this power. Democrats during the Civil War certainly saw him as abusing the power, and many today also still see it as a black mark on Lincoln's record.
When he was president, even in the midst of the Civil War, Abraham Lincoln saw ordinary people twice a week, people who would line up outside the White House office, down the steps, and wait for 10 minutes or 10 seconds with the chief magistrate. The remarkable thing is Lincoln's willingness to see them. And even in the days when he was up all night, when he was in the telegraph office receiving terrible battle news, he said, I came from them and I want to continue my relationship with them. He called these his public opinion baths. So I do think constant exposure to clients, to audiences and the spectators, to editors, all prepared him to not be a snob. I don't think he ever lost that touch. I don't think it was put on. I think it was genuine. Going on the circuit pushed him out to a wider group of people. It forced him to socialize, to entertain, to recruit. So the circuit was crucial in his development as a public person.
Because he was a lawyer, because he was trained in the law, he saw the law as something that was designed to bring order to society, to be there for the good of the people. And that's the way he had approached his presidency. His legal training made him cautious, made him careful, but made him respect the law. And that, in the long run, he knew was the protection for U.S. citizens, was that we follow the law, that we do things lawfully to achieve our goals.
I think a lot of Americans know about Lincoln's early life. He grew up in a log cabin. He had abject poverty. They know about his presidency. They know about emancipation. They know about his assassination. But this part of the Lincoln story often doesn't get the attention that it deserves. And I hope that it gives us an appreciation for just how hard he worked. This was a guy who pulled himself up by the bootstraps, who wanted to make something of himself, and being a lawyer was the way for him to get there.